speaking with me, Tarun Nangia, in a great encouragement to the enforcement of arbitral awards. We have a judgment by Justice Rishikesh Roy and Justice Prashant Mishra. Their words and actions have been encouraging for arbitration in India. And this, in the case of an enforcement of foreign award, the judges have said that the enforcement of foreign award must be refused only rarely. And they have said international and not domestic standards should apply when bias is to be determined. We will get into the details of their observations in a bit, but let me welcome my panel today. We have with us Senior Advocate Percival Bilimoria, who is an arguing counsel at the Supreme Court of India, also does a lot of international arbitrations. Good to see you, Mr. Bilimoria, and looking forward to some interesting insights from you on this. It's also fit to add that in his earlier career, long ago, Mr. Bilimoria practiced as a chartered accountant, so he's a number cruncher. So he can also explain us the complexities of in arbitration in infrastructure and the implications on finance and banks, but that's also coming up on the show later. We have with us Karthik Seth, advocate from Chambers of Karthik Seth. Karthik argues at the Supreme Court of India and also does a lot of arbitrations. And most recently was appointed as a trust advocate for the Leelavati Group of Hospitals. Many congratulations, Karthik, on that. And looking forward to some interesting insights from you as well. At the outset, may I request Senior Advocate Percival Bilimoria to give an introductory comment on this judgment and the law by Justice Roy and Justice Prashant Mishra.
Thank you, Tarun. Quite apart from the Supreme Court, I also appear in several other high courts. This judgment is excellent, both in the way it is written. It's so lucid. Also, that it confirms a couple of nagging issues that have prevailed. We frequently heard criticism that arbitration is not as speedy as one would like and enforcement. Now, I have always said that, look, our law is very robust. It's only when you talk about arbitration, there are two arbitration, Indian arbitration, India-seated arbitration and foreign-seated arbitration. So when you talk about arbitration in India, our procedures, our practices need to improve a little. There's nothing really wrong with the law. This particular judgment pertains to enforcement of foreign awards, and there's a slight difference which needs to be explained at the beginning. If you have an India-seated arbitration, the 96 Act provides for any challenge to the award. It can be challenged only on very limited grounds specified in the statute. And those grounds are crafted and are in line with international practice. So there is absolutely no issue with the law. After the challenge fails, then the award can be enforced. That is for an India-seated arbitration. For a foreign-seated arbitration, it can be enforced straight away, because if you have an award, let's say, in Singapore, like in this particular case, then the party will enforce it against, if one of the parties to the award is an Indian national or an Indian entity, then the assets are in India. So that award will be enforced in India. So there is a material difference between the two situations. The enforcement, there are separate provisions for enforcement of a foreign award. Now here, the challenge that was lodged was on account of bias of one of the arbitration. Now, Christopher Lau is a very well-renowned personality in Singapore. He is also on the board of SIAC. He is a member of 3VB, in London. So eminent personality. And to challenge such a person on bias and on grounds which were very flimsy, this matter, HSBC versus Avitel, is an epitome of a situation where challenges have been raised at every stage. And in fact, the court has called it as speculative litigation. So the challenge in this case that was raised is simply that he failed to disclose now he was representing HSBC. Now, one of the group companies of HSBC, not the award holder, but the group company of HSBC had some dealings with another company in which he was an independent director. Now, if you apply the IBC rules for conflict of interest, that does not require disclosure at all. But it was argued that we need to have a higher standard and go beyond that, and at least disclosure ought to have been necessary. In my view, it is probably impossible that he even was aware that one of the group companies in which he's an independent director had some dealings with a group company of HSBC, the counterparty. And the court has rightly struck it down. In the process of striking it down, it has commented that we need to have a higher standard for how public policy is interpreted. And bias can be challenged as part of public policy because that was defined after the amendment to the law. One of the grounds for challenge is that public policy includes an award which is against the most basic notions of morality and justice, the most basic notion, and therefore bias can come within that.
Point well taken. Thank you for the opening comment. We'll now go across to Advocate Karthik Seth for his opening comment.
Thank you. Firstly, I agree with almost everything with Mr. Bilomoria pointed out, and I just definitely welcome this judgment because any practicing lawyer in the arbitration field in the country definitely wants India to become an arbitration hub. We are having arbitration weeks after week. I mean, almost every city is having an arbitration week these days. So all this is probably happening because even not only the lawyers, but even the judiciary as an institution wants India to have a robust arbitration mechanism. And I believe that in that sphere, this judgment is a very welcome step because this is a post-award execution judgment. Because the major issue which India has faced is the execution of the arbitration awards. The problem is not per se that arbitrations are decided wrongly or rightly. No one challenges the intellect of an Indian lawyer or an Indian judge. The problem is the timeline. The problem is that when do we give and eventually hand over the person what is supposed to be handed over. Now, in this regard, I believe that such kind of, as Mr. Bilomoria rightly used the word flimsy, on these kinds of basis, if a judgment is challenged or an award is challenged, this should be outrightly rejected. And that's what the Supreme Court has done. That, I mean, you cannot, at a belated stage, raise certain issues which you could have raised earlier as well. Hence, I believe, and we are personally seeing it in court, that Mr. Roy has created an image and an impression about himself of being a no-nonsense judge. And this judgment says that in very categorical terms, he is a no-nonsense bench. We will not tolerate anything, be it high-profile lawyers standing for either parties. We will not be cowed down. We will not be going down to any kind of pressures. And we will deliver what is the correct law of the land. So I definitely welcome this.
Point very well taken. I'll take the point that Advocate Karthik Seth mentioned and read out from the judgment. The judges, Justice Roy and Justice Prashant Mishra, say the sort of challenge where arbitral bias is raised at the enforcement stage must be discouraged by our courts to send out a clear message to the stakeholders that Indian courts would ensure enforcement of a foreign award unless it is demonstrable that there is a clear violation of morality and justice. So we see that the honorable judges have clearly veered on the side of enforcement. They are actually sending the message that India is a jurisdiction where enforcement is taken very, very seriously. What led the judges to make that statement? I'll go to Senior Advocate Percival Bilomoria to find out. Can you mute? You're on mute.
Tarun, the point is that ever since the New York Convention, there has always been a pro enforcement bias, right? There is courts have always leaned in favor of enforcement of an award after the New York Convention. You see it in several decisions, and I think Justice Roy, to that extent, is only confirming that the way you enforce foreign seated arbitration, there must be a pro enforcement bias. So unless there are material grounds, and this was definitely not a material ground. As far as bias is concerned, the IBA guidelines lay down, what we practitioners call as the traffic signal, red, orange, and green. And it has been held that the so-called bias that was brought to the notice of the bench did not really fit into it. I mean, it did not even require disclosure. It was a very flimsy ground. So the one of the main aspects of this judgment that really stands out is that it says that we must adopt international standards, not just in bias, but in looking at public policy. See, public policy has been described by jurists as an unruly horse because it is subjective. And then, Justice Roy has quoted, Lord Denning to say that even if it's an unruly horse, it really depends on who is in the saddle. So it can be controlled and it has to be interpreted narrowly. Now, here, the additional point that has been brought in is that public policy must be construed in the international context. This is important because the statute actually says public policy of India. But how you interpret public policy of India must have an internationalist approach. That's the point. And that, I think, is a very major issue here. The one aspect that remains slightly unclear in my mind, because this is in the context of enforcement of a Singapore award. But will that ground of public policy when it comes to enforcement of an award in India, will that also have the same approach? That is something that needs to be seen. It's an excellent judgment. Yes.
Thank you for your input. Point well taken. I'll go to Karthik's side. Now, I'd like to point out, Karthik, one more thing, that the judges have said that it has to be a demonstrable thing that there has been the issue of bias. So unless it has been demonstrated that bias has, in a sense, there cannot be, in a sense, that you hold up an arbitration. The judges have reiterated, again in the same paragraph, if I read ahead, it is clearly said that the determination of bias should be only done by applying international standards. Refusal of enforcement of foreign award should be in a rare case where non-adherence of international standards is clearly demonstrable. These two words, there is emphasis applied, it seems.
Tarun, very, very pertinent thing to be pointed. So what I believe is the emphasis on is, firstly, you do not even raise it in the country of origin. Now, here what has happened is that this point of bias was never raised during the course of arguments. Not raised where, for example, if it's an international award, if either it's Singapore, like in this case, it's Singapore, either Singapore, London, or any other country. You do not raise it in that country while this is going on, while the letters were exchanged, while the pleadings were completed. And it is very pertinent to note that in this Singapore International Arbitration Center, there is a specific way of recording. There's a transcript which is maintained. When transcripts are maintained, for example, it is happening in the 9 judges as well in Supreme Court these days, that a transcript is maintained. Now, when you maintain a transcript, everything is recorded. Nowhere in the transcript or anything it would have been found that even a whisper of a bias would have been raised, except for a very, very pardon my word, but I use preposterous when they say things like they scheduled a hearing during Diwali holidays, even though it was asked for some other date. Is that a reason for bias? I mean, there cannot be. Apart from that, as Mr. Bilomeria pointed out, the other reason for bias, that's also there. In any case, you need to see whom you are talking about as well. I mean, obviously, there have to be grounds, but there is a person of high repute and integrity under the Singapore International Arbitration Center panel who can be arbitrators. There cannot be an outside arbitrator appointed apart from who are there in the panels. Now, as Mr. Bilomoria rightly pointed out, he's a member of 3VB. One of our esteemed bar members, Mr. Gopal Subramaniam, is also a member of that. So, a person of that stature is whom we are talking about. You're casting allegations, that also on absolutely filthy grounds, in an international arbitration, which is going to damage the reputation of India as an arbitration hub. Hence, undoubtedly, this is something which is the need of the hour, where the courts come down heavily with an iron rod and say, enough is enough. When you are questioning an international arbitration award, we need to have proper solid grounds. And that's where morality has been used as the only way this can be set aside. That's what I have.
Point well taken. Going further on the comments made by the judges, they spoke on jurisdiction, where they said the jurisdiction was chose clearly on the perceived neutrality, which is Singapore, which is an arm's length approach because it's a neutral jurisdiction. And this is keeping in mind the principle of party autonomy. I'll go to Senior Advocate Percival Bilomoria. Two things which did arise in the course of enforcement is that objections raised at the enforcement stage, and secondly, the seat was neutral. I mean, so there was no cause for raising these kind of issues. Could you delve into these kind of objections that are raised at the time of enforcement?
It's not really about the seat. The seat, it's the law that is followed. If it is foreign seated, then it's the law of Singapore that will be followed, in which is the curial law. The point is really that they failed to challenge the award. See, it's a Singapore seated award. If it's an India seated award, you go to the courts in India, challenge that award. If the challenge fails, then there is enforcement. Except if you don't file in time, that's a different matter altogether. In this case, they did not challenge this on the grounds of bias or any other bias in Singapore. So therefore, to come at the enforcement stage, it's really speculative litigation, like they've said. The award is interesting also for the, it notes that, look, in such a situation, the Supreme Court has to intervene to set out the law. So more than the merits of the particular case, it is really the observations made. So, for example, it quotes Sangyong, where it says that the most basic notions of morality and justice should be such that it shocks the conscience of the court. So it applies that principle, and it clearly, the court had already gone into the IBA guidelines on disclosure and found that no disclosure is required. So now, before the Supreme Court, what was left really? It was a very clear case in my mind. It was open and shut. And, I must tell you that last week when I was in Bombay, I ran into Darius Khambata, who was one of the counsels. And he told me that, look, this took only an hour before the Supreme Court. It was really an open and shut case, and a case of speculative litigation. I think more needs to be done in terms of shutting out this kind of speculative litigation. And I think this judgment goes a long way towards doing that. It conveys in no uncertain terms that speculative litigation to delay enforcement will not be tolerated.
Ask a question which is common to now both the panelists. That being the one of the final paragraphs that both the judges have authored. It's very interesting. What they have said have a bearing on the investment climate in India, and the judges go forward to speak these lines, which are very, very important, that the long list of events point to the saga of award holders' protracted and arduous struggle to gather the fruits of the award, the pains that an award holder goes through. The award debtors raised multiple challenges and also defied the court's order. They had to serve jail time for just contemptuous actions. But the first two lines, where they highlight the award holder's dilemma, that I have a paper award in my hand and the money never comes. And if that the courts were to enforce, which rightly the two honorable judges have done, it will ensure that the investment sentiment for a country like India remains positive. The courts are actually doing that duty. So, how the court's decisions, in fact, impact investment in India. And we had eminent lawyers like Harish Salve some years ago commenting on that how the courts have a role. If I'm not remember, the former law minister Ravi Shankar Prasad also had said that the kind of disposal that happens in the court can impact investment in India. And I think this is a very positive judgment in that regard. Karthik said, and then we'll go to senior advocate Percival Pillimon.
Yeah. So on that point, as you rightly pointed out, Mr. Salve, I believe spoken on the Vodafone tax case as well. Like how that judgment came and how that judgment was actually very good or whatsoever. Later on, reversed by the government and all those things. So all those things were there at one point of time. But what is very, very crucial here to see is that this sends out a message to each and everyone in the market that Indian courts are not going to let any Indian, their own company as well, run the roost and say, okay, this is my den and I can delay proceedings in the manner I want and I will not pay you. So what has happened here is, in this case, and it's, I believe, I mean, sometimes most of the judgments are reflective of the personality of the judge. And that is where I feel that when you appear day in and day out before judges like them, I mean, complete no-nonsense approach, which sometimes is, you are all, I mean, you can be sometime on the wrong side as well of that kind of a no-nonsense approach, because the patience is very less with the judges, especially on a miscellaneous day. This is to our final hearing, proper judgment. But as Mr. Bilomoria pointed out, that it has hardly took 1 hour to give a judgment like this. So it comes out as a personality of a judge, especially for a junior judge like, for Justice Prashant Mishra to have just recently come to Supreme Court and to be a part of a bench like this and say it with utmost authority that no, boss, enough is enough. We will not tolerate any kind of nonsense. We will not give you I mean, when Mr. Bilomoria says that 1 hour, in 1 hour to decide an issue of such magnitude, it's not about the question of law. Undoubtedly, question of law is a straightforward answer. But most of the judges, I mean, in smaller states I have seen, in Bombay, Delhi, even to an extent in Karnataka, the High Court see this kind of money, so they are not really bothered. But when you go to a Madhya Pradesh High Court or a Chhattisgarh High Court or any other High Court, they feel, oh, it's a 60 million or whatever dollars. They would be reluctant to do it. They would like take their time. They will take their time because they will be scared just seeing the numbers, sheer numbers. But with judges like Justice Roy and Justice Prashant Mishra, numbers do not really matter, whether it's 1,000 crores or whether it is 1 crore or even 1 lakh. It will be about the law per se. And that's what I admire about this bench. And hats off that we are laying down that no-nonsense approach, even though we face the brunt of it at most of the times. But still, it's definitely a welcome step as the officer of the court.
We'll go to senior advocate Percival Bilomoria, but judgment after judgment, if these kind of announcements and statements come out of Supreme Court along with the judgments, I think we will have a positive investment climate in a sense which has the contribution of the judiciary, because really when disputes arise, there is no other way that these can be solved. Over to senior advocate Percival Bilomoria.
Right. So one of the interesting aspects is that the judgment calls this a Pyrrhic victory. Pyrrhic victory is one where, okay, so you won the war, but it was a very high price to pay. It was a devastating price. And this particular judgment has really gone through the motions. One side has chosen to challenge the award on one pretext or the other. One of the other landmark decisions in HSBC versus Arbitral was the question of arbitrability, because one must remember that not all aspects of a dispute can be arbitrated. It's only those. So question of whether there was a question of fraud here, and they challenged this entire reference to arbitration, saying that an arbitral tribunal cannot go into fraud. And that, I think, today, if the student of law, when he reads, arbitration and arbitrability, HSBC versus Arbitral decided by the Supreme Court is one of the landmark judgments in whether fraud is arbitrable or not. So this has run the course over more than a decade, this particular dispute. And I think it has now come to a fitting end, and one hopes that this is really the end of it.
That brings us to the end of this show, where we discussed the judgment by Justice Rishikesh Roy, Justice Prashant Mishra on the enforcement of arbitral awards. A recurring theme now in most disputes where we see they land up in the Supreme Court for enforcement. The courts have stood up to the occasion, and I'm so happy to say that we get to show shows like this. All the promoters watch, the GCs watch. These all people keenly look forward to the Supreme Court of India, because then they are answerable to their investors sitting in foreign countries that you put in money in India. And if there is a dispute, we ought to see the result. We have to pay back the banks, we have to pay salaries also. So money has a ripple effect, and it is with, in a sense, a feeling of happiness that we get to do a show like this when the courts stand on the side of enforcement. It was indeed a pleasure having Senior Advocate Percival Bilimoria, Advocate Karthik Seth from Chambers of Karthik Seth, to take out time and join us today. Thank you so much for joining in. Thank you so very much.
Thank you, Tarun.
Thank you, Tarun. Thank you.